for live.
Ladies and gentlemen, if you confirm we are online, estimated colleagues and friends, welcome to this webinar on rule of law and judicial independence in Europe, the first of, I hope, a long series that is a result of joint organization, let's call co-organization by European EU Law Live and Diritticomparati. As co-director of Diritticomparati, I am personally, as Diritticomparati, part of the team, very proud organizing this webinar with EU Law Live, and especially with Daniel Sarmento. He played a great role in organizing and promoting these events that, as you can see, as a stellar array of speakers. I will introduce the speakers one by one, and also the great discussant in due course. But first of all, let me give you some, let's say, information about the format. First of all, it's a great pleasure to have so many connected, more than 400 registered attendants, and basically the idea is to start with the discussion about the article of President Spano, that was President of European Court of Human Rights, that has been published in the last issue of European Law Journal. The title of the article is "The Rule of Law as the Lodestar of the European Convention of Human Rights, the Strasbourg Court and the Independence of the Judiciary." I will say a few words in 1 minute about it, but just let me give you other information about the format. After the keynote of President Spano, we will have the 3 speeches of the distinguished speakers, and after all, we will have the 2 discussants. Then I will pass the floor and the chair to Daniel Sarmiento for 15 minutes of Q&A. What is very important is that participants should send questions in writing, no live audio or video. And please remind that the session is being recorded and will be available later, both in Diritticomparati and EU Law Live web pages. Last thing, this is just the first part of a project that will see published the papers of the speakers and the discussant, and we will come back to you very shortly on the details about it. Having said this, as I already anticipated, we will start with the keynote speech of the Judge Robert Spano, that, as you know very well, is the President of the European Court of Human Rights, has been elected to the court in 2013 in respect of Ireland. He began its term of office as president May 18 last year. Whilst on the court, President Spano has published important, very important articles on the evolution of the convention system, in particular examining the principle of subsidiarity and the rule of law. Exactly as far as the letter is concerned, the rule of law, the article that today will be discussed, I think it's really playing a crucial role. And so a lot of thanks to European Law Journal for having published, because I think one of the many added values of the article is the exercise that President Spano is doing in unpacking rule of law principle, basically emphasizing the 3-dimensional normative force of the rule of law under the convention. I think this is the best way to identify the right mechanism in order to let emerge all the potentially genetically enshrined in the rule of law principle as the traveling compass, and consequently let the principle at stake play at its best its role of lodestar as suggested by the title. But I think I spoke too much, so I just give the floor, thanking again for the participation, for having accepted our invitation, President Robert Spano. Please, the floor is yours.
Thank you very much, Oreste, Professor Pollicino. The words you just espoused here at the end, I should have had them in the article as such. They were very well spoken. Also, let me thank Professor Daniel Sarmiento for for the organization of this event, which I'm very happy with. And last but not least, Editor-in-Chief of the European Law Journal, Karin Kohn, who also assisted me quite in the editing process of this article. I received extremely good and incisive comments from the editor when we finalized the article. I said on 28 January during the court's annual press conference, and I've said this in quite a number of speeches over the last year, we are going through a transformative period in Europe. The pandemic comes over and above an already difficult political environment. Let's just be frank. My view has been that silence is not an option. Sustained debate is required, and an increased awareness of the importance of the fundamental structural components of democracy, human rights, and the rule of law. Of course, extrajudicial expressions by a judge, as my colleagues will know, is whether written or oral, is one which must be performed with caution and prudence, but it is a part of the ongoing debate we are having at the moment. Now, the main aim of this article was to try to demonstrate the normative character of the rule of law, and in particular, its status as a constitutional principle within the whole structure and edifice of the convention. There is a reason I term this principle the lodestar of the convention system, as I try to demonstrate in the article. Now, I ask you, why is this important? Why is it important to give life normatively as a matter of law to the concept, the principle of the rule of law? I think we must realize that the current narrative as regards the rule of law is one which is fraught with danger. We must be careful that the rule of law not become a political slogan or it be diluted to mean everything and nothing. It is not just a political ideology. It is not even just a moral imperative. The most, I think, important element to the rule of law, it is that it is a legally binding norm which cannot be reformulated or redefined at will, because such endeavors may ultimately end up not serving the rule of law, but the rule of lawlessness. So therefore, it is important that the debate on the rule of law be as far as possible conceptualized, theorized within the current constitutional framework, both under the convention and also under the EU system in place. I admit to you, it's a complex task indeed to construct a composite normative framework for the rule of law. This is a concept that has been debated for decades by legal philosophers, political scientists, and so forth. But what I tried to do in the article is I tried to extrapolate from the convention's preamble, its text and structure, and of course, mainly the court's case law, a certain view, a framework in which one can analyze the convention concept of the rule of law. Now, views may differ on that, but I present a certain viewpoint in that regard. The article has four main parts. The first deals with what I call the conceptual core of the rule of law and its individual components as forming part of what the court has called or termed a European public order. The second part deals with the normative status of the rule of law, and as mentioned by Professor Pollicino, its three dimensions. This discussion has a particular reason in the article, an aim. It is the conceptual basis for a subsequent exploration and analysis of the court's case law and the independence of the judiciary. I wanted in the article to try to theorize from the court's case law, from the preamble text and structure, to try to create a conceptual platform so as to discuss the independence of the judiciary as coherently as possible. The fourth and final part is no less important, and that is an analysis, or at least a discussion, on what I term the symbiotic relationship between the Strasbourg Court and the Court of Justice of the European Union. And there, I'm very happy to have my colleagues from that court join me here today and us in presenting their views. Let me just summarize very briefly each of these four parts. So the first part, one can ask, what is the ideological core of the rule of law under the convention? Now, I want to make clear that whatever one's view on the rule of law as a general matter of legal philosophy or as of legal theory, I think one can, under the convention, extrapolate from the preamble, from the nexus in the preamble to the 1948 Universal Declaration of Human Rights, from the journey as it started in 1975 with the famous judgment in Golder versus the United Kingdom and subsequent trajectory of the convention case law, one can extrapolate from that a particular convention-based concept of the rule of law, which I tried to demonstrate in the article, is, I think, at the basis of a conceptual core encompassed around protection of personal autonomy and the prevention of the arbitrary use of governmental power. It is important to realize that the court's case law on the rule of law is rich and goes back many decades. However, as with any concept of law, that concept has gone through a development. It goes without saying, we have given life to the rule of law in various ways throughout the case law. And it is important now, I think, in particular in the current framework, to try to understand what one can read from the case law and what one can extrapolate from the case law. More recently, one has seen, I think, the court moving further in trying to bring to bear the different manifestations of the rule of law under individual articles, and importantly, also the member states' commitment to the rule of law by having, by sovereign choice, decided to become member states of the Council of Europe by the court's invocation of the statute of the Council of Europe, which the court has rather recently started to include references to in the case law, in particular Article 3 of the Statute of the Council of Europe, and made it very clear that by signing up to this convention, the member states are therefore signing up to a particular framework of a European public order. It is done by sovereign choice. And whilst you are a part of that convention framework, you are within a conceptual composite frame which does not permit for the redefinition or the reconceptualization of the underlying premises. Now, I end this part by extrapolating a few points. There can be no rule of law if those in power are not themselves subject to the rule of law. This seems to be a rather self-axiomatic point, but it is a point which is necessarily worth emphasizing at any given moment. There can be no rule of law without independent judges to interpret and apply the law when disputes arise. As my counterpart, President Lennartz, has said, within the EU system, there simply cannot be any convention system without independent and impartial judges to interpret and apply the convention. Finally, there can be no rule of law if those in power do not respect and enforce judgments rendered by the courts. Now, my second part, which has already been alluded to by Professor Pollicino, is, I admit, a rather ambitious attempt to try to identify what the court means by one of its famous statements of principles, and that is when the court has said in many, many cases that the rule of law is inherent in all the articles of the convention. The questions that arise are, how is it inherent? What is the court referring to? How does this statement manifest itself? I attempt to offer some answers. The first answer that I want to provide is that the rule of law operates first as an interpretative tool. the court is seeking the best rule of law conforming understanding of the convention provision in question. And that operates in many different ways, as I come to when discussing what perhaps I try in a rather novel way, is to give what I term the three-dimensional normative force of the rule of law under the convention. Now, what is my aim here? My aim here is to try to demonstrate that the rule of law as a norm, a legal norm, operates in different ways in different types of cases in relation to different types of provisions. Now, the first dimension of the rule of law under the convention are those cases where the rule of law operates as a legal principle. This is what I term the organic dimension. It is the dimension in which the rule of law is optimizing the force of the convention provision in question. The most apt example of this is when the rule of law is used to maximize or give force to the requirement of prescribed by law under Articles 8 to 11 of the Convention and Article 1 of Protocol 1, requiring legal certainty, legal stability, and that executive power is not unfettered, that discretion of the executive must be limited so as to optimize the potential of legal certainty when restricting convention rights. This is the rule of law in its legal principle or organic dimension. The second dimension is the rule of law when it is a fixed rule, when it is in its functional dimension. The most classic examples are Article 5, deprivation of liberty. There, the rule of law is the actual functional component of the human right in question. And the same goes for Article 7, nullum crimen sine lege, where actually the rule of law is manifested as the actual human right that is being protected. But I started to wonder, are there examples where the rule of law actually operates as both a legal principle and as a rule with fixed content, and what I term in the article a hybrid dimension? The reason I think it's important also not to foreclose that possibility is that it gives quite good insight into the way I think the rule of law has been extrapolated and dealt with under Article 6 and the independence of the judiciary requirement. Let me then turn to that, the third part. In the article, I begin my exploration of the independence of the judiciary by making a distinction between de jure and de facto independence, which is a bit of a different classification from the one we see in the Luxembourg court, which has made a distinction between external and internal judicial independence. I'm not going to go into all of the various judgments rendered over the past decade or so dealing with de jure independence when it comes to the appointment of judges, dismissal of judges, security of tenure, cases like Alexander Volkov versus Ukraine, Baca versus Hungary, Ramos Núñez de Carvalho versus Portugal, Denisov versus Ukraine, and so forth. Recently, on 1st December, which I will mention, on 1st December 2020, the court delivered judgment in a very important case called, and I'm the only one in the panel that can pronounce this correctly. This is Guðmundur Andri Ástralsson versus Iceland from my home country, where the court for the first time came to the conclusion or dealt with whether the appointment of judges, the appointment process itself would fall under the concept of establishment under Article 6 of the European Convention on Human Rights. Previously, on 26 March 2020, in the HG and Simpson cases, the Grand Chamber of the Luxembourg Court had dealt with a similar proposition within the context of EU law in Article 47 of the Charter. The court found that, yes, appointments fall under Article 6 of the Convention, but importantly, one can see there the court applying the hybrid dimension, in my view, to its fullest by looking at the establishment requirement as a standalone requirement under Article 6, thus optimizing the requirement of fairness as a structural premise for any potential claim of unfairness being made out in the particular circumstances of the case, not necessitating a subsequent analysis if a judge is appointed in light of or in non-conformity with Article 6, thus fulfilling the very high threshold, the test as provided by the court, which I explain and is explained in the judgment, then that suffices for finding a violation of Article 6. Let me then finally turn to this last part of my article, which deals with the Strasbourg court and the Luxembourg court. The point I make there is, first, synergy between the two systems is, in my view, absolutely crucial. Uncertainty is poison to the rule of law. It is a commitment which both courts, in my view, must bear in mind, a commitment to a sustained methodological synergy when it comes to what I would term the structural components of EU law on the one hand and convention case law on the other, which manifests itself very readily when it comes to the independence of the judiciary. And there we have common building blocks, which are extremely valuable for both systems, as I tried to demonstrate in the article. The fundamental values are the same. Article 2 on Treaty on the European Union and the value-based system of the convention are, in my view, quite symmetrical, which is, of course, a very important methodological starting point for both courts. The Strasbourg court has made that clear, for example, with its famous Bosporus presumption of equivalent protection between the two systems, demonstrating its respect for the underlying human rights system within EU law. But as the case law of the Strasbourg courts demonstrate, the court must, of course, enforce the minimum guarantees under the European Convention on Human Rights, and therefore must be in a position now and then, when called upon to do so, to assess whether an EU state, in restricting convention rights, but on the basis of EU implementation of law, has conformed to the convention in that respect. An interesting question, which I allude to but take no position on, as I'm not in a position to do so, is whether and to what extent the Luxembourg court's case law in the field of the European arrest warrant and the independence of the judiciary conforms to Article 6. This is an open question. We haven't dealt with it yet. There are some elements which I include in the article, and I would be very interested to hear if in the discussions whether other points of view are forthcoming. So to conclude, I will here adopt some of the concluding paragraphs of my article. Some have recently asked whether the rule of law has become a worthless slogan, a fantasy that has lost all semblance of realism in our polarized world, a world increasingly fraught with divisions, originating not from mere reasonable differences of opinions, but from dramatically clashing visions of what constitute first principles of communal human life. My view is there is a clear answer in the negative, and as I hope the discussion in the article and what I've said this afternoon conveys. It's important to realize that attempts to legitimize relativistic conceptions of the rule of law, which unfortunately are quite often tied to politics of national identity and perhaps parochial definitions of the common good, should be rejected. The rule of law under the convention, which the court has said often is a fundamental component of European public order, is conceptually incapable of being transformed to fit the political agenda of those that seek unfettered power, coupled with the subjugation of independent judicial review. The principle of the rule of law, the Convention's lodestar, is organically embedded within an international system of law which rejects unequivocally the arbitrary use of governmental power. Thank you very much.
Thank you so much, President Spano, because it's clear emerging from this inspiring speech the effort of the article of a comprehensive systemic reading of the principle against any risk or even temptation of fragmentation or jeopardization. I think this is very important. Like it is important to build a bridge, if we can use these metaphors between Strasbourg and Luxembourg. This is true for every field, in particular for rule of law. This is, I think, a good assist for starting the part in which the three distinguished speakers will address issue and basically foster the debate around the article. The first speaker, she's Krystyna Kowalik. She's judge at the General Court since 19 September 2006. She's professor in Poland of European law, among many other things. A book in French of 2018 on protection of fundamental rights in EU antitrust, and the editor and the co-author of the biggest Polish commentary to the Treaty of Functioning of European Union. Please, Krystyna, Judge Kowalik, the floor is yours.
Thank you very much. It is a privilege and a pleasure to be invited by Professor Pollicino of Diritticomparati and Professor Sarmiento from EU Law Live. And it is as well quite an intimidating factor to be speaking just after the president of the court, of the Strasbourg court. But I have to say that the article of Professor Spano is very, very timely. Jurisdictions are expected to adjudicate, keeping as neutral in respect of the interest exposed before them as possible. And there are many cases pending dealing with the notion of the court established by law, with the independence of judges. And all this comes with the big question: what do we understand under the notion of the rule of law? And I would like to address 3 points commenting on the article of Professor Spano. First, from the European Union perspective, I would like to say a few words on the notion of the rule of law in the EU system. Then, as one of the organic components of this rule of law, I would like to address a few words on the judicial independence. And third, I would like to say a few words about what Professor Spano called a symbiotic relationship between Strasbourg and Luxembourg in one of the last parts of his article. So first, as to the rule of law within the European Union system, it forms part of the European legal order, and it can as well be called a constitutional principle. It is reflected in Article 2 next to the democratic character of the Union, among other values. And it forms a basic element of trust in the system of the European Union, as without it, the Union would not function as a space of liberty, security, and justice. And this element of trust was underlined for several times by the Court of Justice, in particular in cases where the problem of perhaps a systemic breach of judicial independence occurs. And these elements of rule of law are gradually being analyzed by the Court of Justice because of this problem of trust. And when we look at this rule of law principle, it first and foremost means and requires alignment with the principle of legality, which means public authorities should act within limits of law according to democratic values and in respect of fundamental rights. It seems almost trivial to say this, but the rule of law is in this context really exercised by the courts, because only the courts are really able to verify if actions are in accordance to the legal rules and legal reasoning. And to keep the rule of law, we need independent judges. Therefore, the second element, the judicial independence as a component of the rule of law, bring us to ask ourselves a question: what does it actually mean to have an independent court established by law? And one of the most seminal judgments on this is the Portuguese judges case of 2016, where actually the Court of Justice said that the judges, the national judges, are just as well as the Court of Justice taking care of guaranteeing the rule of law within the European Union, because without their independent review of actions of authorities, this system will not work. And of course, this brings us to sub-questions. I will a little bit simplify it, but there are two questions. What is this independence and how it can be guaranteed? And President Spano already mentioned this notion of two aspects of independence, namely the external aspect and the internal aspect of independence. It has been illustrated by the one of the cases concerning European arrest warrant, the LM case, played between Ireland and Poland. And without getting into detail, the external aspect of judicial independence means that there is no external intervention as to the actions taken by the court. And the internal aspect of independence means that there is an idea of neutrality, of absolute neutrality in what the judges are doing. And now, how can we actually guarantee this absolute independence of the court in question? The guarantees are, I would say, institutional mainly, because we are looking at the composition of such a body, of its appointment, the stability of its length of service, and the stability of being perhaps removed from the office. And the case Simpson, where actually the Court of Justice was looking at the calling into office of the European judges, is a good example of how difficult it might be to adjudicate on those issues. But 2 points were important in this Simpson judgment. First, the Court of Justice stated that it is a matter of public policy to verify whether a court is, or whether a judge is called into office in the proper way. And every court is obliged to check whether, as composed, it constitutes such a tribunal that is independent. And the second important issue in this judgment is that there is a test introduced in this judgment that not perhaps every violation in the procedure of calling into office is important. We need to look for something that is called a fundamental breach test. We need to identify a real risk of reasonable doubt that the outside public might perceive the court in question as not being independent. And this judgment introduced, I would say, a certain gradation, but it's as well a certain reasonableness in an assessment of requirements of independence, because the problems with procedure can occur, and only serious problems can really lead to putting into question the notion of independence of the court. And now to the third point, the symbiotic relationship between Strasbourg and Luxembourg. Of course, according to the Charter of Fundamental Rights, European courts, both General Court and Court of Justice, are bound by the Convention and are supposed to treat the Convention as a minimum standard of rights. And I think we have an alignment in reasoning of the Court of Strasbourg and Court of Luxembourg as far as the court established accordingly to law is concerned, and as well as to the notion of independence of the court. But I think we still wait for exact scope of definition, what comes as a consequence of certain breaches of those guarantees. And perhaps I might be wrong, of course, but I think that there is a suggestion in the article of President Spano that Court of Justice is facing some doubts in as to the trust in the system in the situation of systemic breaches of independence. And I think this the judgments concerning this concerning the independence of the judicial authority or this disciplinary chamber in Polish Supreme Court, they are already bringing in elements of the answer how we should react to certain breaches of the rule of law. But of course, it is an open question whether this answer is correct and whether the Strasbourg court would perhaps suggest to us a different way. So to conclude, I think that we face in the jurisprudence of the Court of Justice and the jurisprudence of Strasbourg Court something that could be called a mutual inspiration and something that could be called an axiological convergence. In a way, we use probably the same criteria to identify the rule of law and as an element of the rule of law to identify what does it mean that the court is established according to law and that the court is independent. But this axiological convergence is probably prone to be further developed, and I really welcome especially the last part of the article of President Spano, where he is in some points signaling the persisting differences or the persisting questions in the jurisprudence of the two courts. And this axiological convergence and this mutual inspiration, they are both necessary if we consider that we are talking mainly about national judges, the judges at the national level, who are at the same time European judges, bound both by the convention and by the EU law as such. And I would say that we are actually living in very interesting times where those questions perhaps may be answered. How to be an independent judge, being at the national level a European judge. Thank you very much.
Thank you very much, Christina. Judge Kowalik, because by underlying the axiological convergence, in a way, there is a clear reference to a constitutional category of convergence through values. And this is, I think, the best way to introduce next speaker, that is a constitutional law professor, Giovanni Pitruzzella, Advocate General at the European Court of Justice since October 2018, and many books, the Handbook of Constitutional Law, among the most successful in Italy, and his last book is Hate Speech and Disinformation from European Constitutional Perspective. Advocate General Pitruzzella, the floor is yours. Thank you very much.
Thank you, Oreste, and I would like to thank a lot you and Daniel Sarmiento, because it's an honor and a pleasure for me to participate to this very, very interesting webinar. President Robert Spano's article on the rule of law is, in my opinion, a source of fruitful thoughts and inspirations since the inception, when he adopts the metaphor of the lodestar. As a star which is used to guide the course of a ship, the rule of law is used to guide the judicial interpretation of all the articles of the Convention and to frame the relationship between the Court of Strasbourg and the Court of Luxembourg. The jurisprudence of the two European courts highlights some fundamental features of the relationship between democracy and the rule of law in Europe, the scope of judicial independence, and ultimately some characters of European constitutionalism. I am well aware that this subject would require a deep and long analysis, but the nature of my intervention obliges me to use the excels instead of the scalpel of the academic. The literature on the topic is as vast as the ocean. Nevertheless, the meaning of the rule of law is strikingly elusive. There is no consensus, at least no overall consensus on the subject. But if we leave the philosophical and doctrinal approach and we follow a legal approach based on the judicial interpretation of the Convention and the treaties of the EU, our understanding becomes easier. In this perspective, we can say, according to the jurisprudence quoted by President Spano, that the European pluralistic constitutional order rejects the thin theory of the rule of law. The concept is wider than the idea for which state power must be exercised in accordance with promulgated, non-retrospective law made according to established procedures. This theme theory dominated the liberal constitutionalism of the 19th century, but the weak meaning of the rule of law became unsatisfactory for the liberal democracy of the 20th century. The reason which brought to the reject of the theme theory are very well expressed in this sentence of Joseph Ratz. A non-democratic legal system based on the denial of human rights, on extensive poverty, or racial segregation, sexual inequalities, and religious persecution may, in principle, be conform to the requirements of the rule of law, better than any of the Western democracy. It will be a worse legal system, but it will excel in one respect, in its conformity to the rule of law. The law may institute slavery without violating the rule of law. Our democracies cannot accept this thin version. The cornerstone of a contemporary constitutional in Europe is the guarantee of human dignity and human autonomy, which is the prominent foundation of a very large set of fundamental rights. It's the source of inspiration of the Convention of Human Rights and Charter of Fundamental Rights of the European Union. This cultural, political, and juridical context brings the European courts to link the rule of law with democracy and fundamental rights. The judicial pronouncements of the Strasbourg court, quoted by President Spano, suggest that the rule of law under the convention system, and the same can be predicated for EU law, is not understood as a purely formal concept limited in its scope to the thin version advocated by some scholars. Anyway, I wonder whether all this means that under the convention system and EU law, we find more direct resonance in the theoretical account presented eloquently by the late Lord Bingham, quoted by President Spano, encompassing a more substantive view, which holds that the rule of law is not satisfied unless the content of law is virtuous. In this day, this means that the rule of law should include the panoply of human rights. And according to some documents of the European Commission, the freedom of the press, pluralism, and free elections. I have some doubts that the above mentioned large version of the rule of law is the right one. The reason is well expressed by John Laws in a recent book. John Laws observes that if we adopt the Think version, the rule of law lacks any distinctive meaning and is not an autonomous principle at the end of the day. If the rule of law overlaps with democracy, we lose the complexity of the relationships between the two principles and some fundamental dynamics of our constitutional systems. The coupling between democracy and the rule of law expresses the virtues of liberal democracies, but the rule of law does not overlap with democracy. Democracy's flag is the authority of the people's will, while the flag of the rule of law is the principle according to which society is governed by law. Government by the people and for the people is different than government by the law. Hence, the tensions between the two principles. We cannot be blind. On the contrary, we should see the structural and unavoidable tensions between the two sources of legitimation, and we should found an accommodation. The so-called liberal democracies made a hard choice in favor of an absolutist version of democracy, which threatens the rule of law, but the obligations of the states under EU law and the convention system reclaim a very different solution, which respects the rule of law. An accommodation between the claims of the rule of law and the claims of people's sovereignty must be found in order to create a constitutional balance. But in order to understand the source of tension between the two principles and reach the proper balance, we should define their precise scope. Thus, how should the rule of law be properly understood? Firstly, it must include the theme theory. As President Spano points out, the foundational moral idea behind the rule of law, which lies at the core of the convention protection, is the respect for personal autonomy and exclusion of the arbitrary use of governmental power. For this reason, the law must be transparent, stable, foreseeable, and allow for mechanisms of dispute resolution that are independent and impartial. The thin version of the rule of law restrains political power only by insisting on proper procedures for the making and application of the law. This could be, as I said before, unsatisfactory. In effect, the thin theory, as generally understood, implies something else, that is judicial supervision of state action. But unless the judges are independent and impartial, there is no point in having them, since if they are not, their decisions have no more value than if they were made by the reviewed body itself. The version of the rule of law developed by the European courts goes beyond the thin version, especially because it involves the right to an effective judicial remedy and the independence of the judiciary, which has a very broad meaning. According to the Court of Justice, this requirement of judicial independence falls within the essential content of the right to effective judicial protection and the fundamental right to fair trial. According to settled case law, the guarantees of independence and impartiality required under union law presuppose the existence of rules, in particular as regards the composition of the body, appointment, term of office and grounds for abstention, of challenge and dismissal of its members, which removes any legitimate doubt in the minds of litigants as to the impermeability of this body with regards to external elements and its neutrality in relation to competing interests. In particular, it is important that judges, according to the jurisprudence of the Court of Justice should be protected from outside intervention or pressure which might jeopardize their independence. The rules concerning independence must in particular make it possible to exclude not only any direct influence in the form of instruction, but also more indirect forms of influence likely to influence the decisions of the judges concerned. A similar line of reasoning is adopted by the Court of Strasbourg, especially when the court pays attention to the requirement of de facto judicial independence. But, in my opinion, it is noteworthy to add another aspect. The meaning of any given law is very often uncertain. This is true for domestic law, but also for European laws, for the treaties, and for Convention of Human Rights. The more the legal text is the product of a political compromise, the more its meaning is ambiguous and uncertain. As a consequence, there are two circuits, two mechanisms of lawmaking. The political mechanism based on people's vote, the parliament, and the political will expressed in the statutes or in European laws, and the judiciary mechanism, whose output is legal interpretation. Judicial interpretation is a part of the lawmaking process, and judicial interpretation is a creative activity. The status meaning must be independently decided to satisfy the rule of law and protect ourselves against the caprice and the arbitrary of the rulers. However, can citizens be protected against another form of arbitrary, the one of the judges? Some scholars, in fact, fear le gouvernement des juges. As Aaron Barak wrote in his book on judges' discretion, the fundamental question is not whether discretion should exist, but where a democratic society that is governed by law should set appropriate limits on discretion. I think that the answer is that judges should implement, when they interpret the law, some objective standards, which are mainly the constitutional principle underpinning the legal system in which they operate, together with some tools elaborated by the jurisprudence with the aim to limit the arbitrary use of power, such as proportionality. These standards limit and guide their discretion. The law thus made will give effect to standards that are not merely the creatures of the rulers who made the laws or the individual judge who interpret it. These standards can also guarantee the coherence of the whole legal system, which is an aspect of legal certainty. Among these general objective standards, there is also the rule of law. As President Spano points out, the rule of law has different dimensions. The rule of law is identified in a set of specific rules, which I mentioned above, but it is also the principles which provides a methodological point of departure in the interpretation of any legal provisions in order to pay due respect for the national autonomy and dignity of human beings and to preclude the arbitrary use of governmental power. If judges interpreting the law dismiss these objective standards and follow their subjective preferences and political choices, they go beyond the boundaries that in a democratic society limit their role. If politicians threaten using the law or other political means the independence of the judiciary, they violate the obligation they bear in a system based on the rule of law and break the constitutional balance. Thank you very much for your attention.
Giovanni, because Professor Pitruzzella gave a really comprehensive overview with, I would say, strong normative stand. So thank you very much. I think it's almost ready for the publication. So great that you did this work. Thank you very much again for this. And now let's go back to Strasbourg, in particular to dear friend and estimate judge, Judge Raffaele Sabato, that until just a brief presentation, until election to the Strasbourg court in 2019, he served for 19 years as a member of the Consultative Council of Europe, judge at the Council of Europe. This is the body that is entrusted with a consultative role in the area of judicial independence, in which, by the way, is also set as vice president and the president. He was therefore, as you can imagine, involved in a drafting of several opinions relevant for the topic of judicial independence and impartiality. And by the way, it's also worth to remember it's a great work in relation to the Magna Carta of judges. Having said this, I think there was really no best way to conclude this round of speakers, giving the floor to Judge Sabato. Please, the floor is yours.
Thank you, Professor Pollicino. I'm grateful to you and to the Diritticomparati and the EU Live teams. I was glad to also meet Professor Sarmiento. It's a great privilege to be called on behalf of the court to comment on an important article of my president, to whom I also I pay tribute. There are other colleagues and members of the registry connected, so it's a great responsibility that you place on me, and I will not escape it. The article we are called to comment upon can be read and should be read at different levels. And of course, I'm surrounded by constitutional lawyers and I'm not. So I feel a little bit worried. So I thought I would concentrate on a few topics that maybe you were very kind in introducing my little work in the area of independence of the judiciaries in Europe. I will try to put in these few remarks, I will make my past working experience. So I would say, first remark, why this article is important and why is it useful for me as a former national judge and a present day Strasbourg judge. It is important, I think, because first of all, it is an article by the President of the European Court of Human Rights. And this court speaks mainly with judgments and decisions, but also through the voice of its presidents. It has been like that in the past. We have had difficult times concerning the court and concerning the environment in which the court acted. It is like that these days. And I would say that President Spano, just like his predecessors, is doing an excellent job. He has concentrated, I would say, his public speaking in the area of independence of justice in general, of the importance of independence of judiciary for the rule of law, and I would say that outside observers should be careful and aware to distinguish between this sort of diplomatic public role in which things are said at one level, and of course our judicial activities in which things are said at other levels. Misunderstanding in these are not beneficial, I would say, for the role of the court and the rule of law in Europe. Why is it useful? I can give several examples of why this article is useful for me, maybe for my colleagues. I will choose one. Of course, the architecture of the article is very complex. We have commented on that already. But I would say that I would be ready to make use of this theory of this three-dimensional normative force of the rule of law, and especially of where President Spano places the concepts concerning independence of the judiciary. He says it very clearly in the article. He says that independence of the judiciary is probably placed in the what he calls hybrid part of this three-dimensional construction. So what in practice, in my hands, this conceptualization would serve is that independence is at the same time a principle and a set of rules. And as a judge in Strasbourg, I'm very interested, because of course the set of rules concerning independence, impartiality, etc., are very detailed. Probably Article 6 is one of the most detailed provisions we have in the convention. But we need, and the article gives us an opportunity to do that, we need to do away from details and also join details with principles. And I think that the court will be called, has already been called in the past, to use principles even where the convention gives us specific norms, and we will need principles in the areas of independence. And I will not pronounce it as distinctly as our president, but I would say that the recent judgment in Gudmundur Andri Astradsson is an example of that, because it develops many principles, but we have had many other decisions which have worked on principles, Baca, Ramos Nunez, and also Alexander Volkov and Denisov, in the area of what is the role of self-government for the judiciary and other things that you could not, and of course Alaaddin Demirtas, which probably I will say a few more words on. So this is the use I would make of this placement of the role of the independence within President Spano's construction. Second example, he has drawn, taking it, of course, from some hints that appear in our judgments, this concept of independence de jure and de facto. I will, I don't have cultural tools to deal with concepts of such a kind. But what I see in practice is that especially independence de facto is an open window on the future. So just like this hybrid conception opens to us a window on application of principles in an area which we thought until recently was governed by details, now this independence de facto gives us the opportunity to assess, and the court does it every day in other areas. Let's think of Article 8, for example, to assess factual circumstances surrounding specific normative or other factual situations. A joke that my Italian colleagues and friends will understand when I read Alexander Volkov and especially Denisov stating the principle that since the composition of the joint chambers of the Supreme Court are governed by the same persons that appoint judges to that formation of the Supreme Court, and this is of course a sort of breach of independence of judges that are called to rule on the legality of a judge's dismissal. I said, oh, that's the same thing we have in Italy. And there we have the factual addition. Of course, this circumstance has to be assessed within the general system of the country and other guarantees and safeguards. So you see that you know, especially in the area of independence, the general approach is very, very important. I'm grateful to Robert Spano to have it underlined, and especially to have given one more concept which is coherent with this other concept that he has developed over the years, you know, this bona fide assessment of behavior of respondent states vis-a-vis the obligations of the convention. The second remark I would do, and I will take 3 minutes to say that, is that, you know, if I concentrate only on section 4 of the article, I would gladly see that the theory that President Spano builds on Gudmundur Andri Astradsson, together with the other judgments I mentioned, is very useful to deal with the independence of judiciary. We have, of course, a problem of independence of individual judges. He deals with that also in a footnote and says very prudently, and this is one other thing I think we have to appreciate rather than criticize. I am not taking a position on that, but let's remember that Judge Sicilianos, President Sicilianos, wrote an opinion in Bacca saying, I would not be against constraining on Article 6 also a rule or an interpretive tool which would allow to say that the convention also protects independence of individual judges. And we have seen that this has grown over the years. Because of course, Volkov and Denisov, etc., we are talking of individual judges. And this is in part, I think I am authorized to mention that I think we will have more cases in the future. Individual judges taking the role of bringing to the court also phenomena concerning countries. Of course, we have to understand that Strasbourg does not have, I'm grateful to what Judge Kowalik said before, we don't have the possibility to use this sort of indirect use of preliminary rulings that the judges invented, started from Association of Portuguese Judges up to the Polish judges, but this is the future, this direct contact between associations, individual judges, and the European courts. So I would say that this is also one more important bearing of President Spano's article, although it's very, I would say, prudent and also only a suggestion. It is very important that we deal with this topic. Going to the fact that we need to also be prepared to assess factual situation in individual countries that could be part of the assessment of possible violations for the independence of the judiciary, the concept that I already mentioned at the very start of independence de facto is also very important because it sort of merges with other indications that at least in Strasbourg we have from soft law coming from the Council of Europe. And I come to my little experience. President Spano refers to this independence de facto concept, saying that Strasbourg has to assess and will assess in the future the general environment, the public statements against the judiciary, how independence is respected and practiced in practice. Sorry that I'm repeating, in a specific country, this will be very important for future cases. He mentions Kinski and Rinau versus Lithuania. But we have, for example, this recommendation of 2010 that Oreste very kindly mentioned, which goes further and can provide food for thought for future judgments of the court. Let me remember only two provisions of this recommendation, which of course is soft law. It's the Committee of Ministers speaking to the states, but the court can make use of it. One pro-judges and the other one against the judges. The one pro-judges is that this paragraph 18 of this recommendation number 12 of 2010, on which we worked a lot, and that's the famous provision saying when commenting on judges' decision, if they decide to do so, members of the executive and the legislative should abstain from infringing judicial independence. If they decide to make criticism, it should be limited to criticism that does not diminish independence. They should never suggest or take actions, I'm sorry, I have to quote by heart, that would involve non-execution of decisions except the will to bring an appeal. So this is very important in the area of de facto and transforms the de facto concepts into, I would say, de jure concepts. That would be a movement for the future. Against the judges, there is another paragraph, this paragraph 20, which deals with the topic that Oreste Pollicino is a specialist of, awareness and reactions to news and information, and also diffusion of information and how you balance this in a society. Well, this rule going against the judges that isolate themselves says that judges should keep informed on societal developments, and they should be aware of society's expectation and should be ready to take permanent feedback coming from society on an institutional basis. I will finish by making mention of the fact that in Italy we are undergoing an important crisis concerning credibility of the bodies self-governing the judiciary. And this was, of course, the case, and Robert Spano mentioned this in a side argument in Salahattin Demirtas. There is an underlining of the fact that if you control High Council for the Judiciary, then you control appointments in the judiciary. And if you join this, let me make this parallel with Gudmundur Andri Astradsson, dealing with the appointment of judges, you have a closed circuit, which can be very dangerous for society. I learned, and that's my final thing, that one opinion I concurred in working on of the Consultative Council of European Judges, opinion number 10, dealing with the role of councils for justice in society. I think that is the title of that opinion, is going to be revised on the light of present development. It's the first time that the Committee of Ministers authorizes a revision of a previous opinion of the Consultative Council of European Judges. We'll see what happens, but I would say that the court, thanks to Robert Spano and this article, is ready with a conceptual framework, which of course can be completed and supplemented, but you know, I think that also probably on behalf of my colleagues, we are very happy for this article. Thank you so much.
Thank you very much, Judge Sabato, because in a way, your approach is absolutely on continuity with the other speakers, especially with the keynote President Spano, because he tried to let emerge the need of no fragmentation and systemic approach. You, on the other hand, are letting emerge the importance of effectiveness in the rule of law enforcement. That means how de facto, what we would call from a constitutional law, material constitutional becomes effective and then becomes really a traveling compass and not just a formalistic tool. I think it's very important. Like it's also very important, on the other hand, that you are, all of you are really great in keeping the time frame. This means that we will have maybe the possibility of 2 rounds of question and answers with the speakers. And now, without further ado, I will go to present the first discussant that has been already mentioned, because in a way is the engine, she is the engine behind the publication of the article, Karin Kohn. I hope I said correctly, editor-in-chief of European Law Journal. She's doing a great job at the European Law Journal, but I would like just to remind that she is also Global Program Director at the Center of Artificial Intelligence and Digital Policy, and she's Senior Lawyer Course Director at the Academy of European Law. Karin, the floor is yours, and thank you very much for what you're doing.
Thank you very much. So for first round of thank you anyway, because I think it's always important. Thank you, Oreste and Giuseppe, on behalf of Diritticomparati and Daniel Sarmiento from EU Live for this wonderful collaboration. Indeed, I think it is a very timely one. So today we have this debate between European Court of Justice judges and judges from European Court of Human Rights. So thank you, Robert, Cristina, Giovanni, and Raffaele. It is very, very important we're having this debate, but indeed there's another dimension, which is a national one. And one of the reasons why it is not today is also one of the reasons why we have postponed the special issue on the rule of law that we will have. So you already have Robert Spano's article, but actually we will have a full session, dedicated session to the independence of the judiciary with contributions from national judges. And I think that it is very important for us to tackle, for example, the recent case by the District Court of Amsterdam related to the European warrant arrest, and the fact that actually Polish courts are not always established by law. It's the first time that it has been decided, so it's important. And almost contemporaneously, we have a case by the Polish Appellate Court, which precisely said that exactly the same in relation to Judge Tuleya. So these are very interesting developments, and we will tackle them in the European Law Journal, also because we are all waiting this week for a very important court case by the Court of Justice, and you've been wonderful in avoiding this topic. I understand that. So we will have to wait for the decision of the Court of Justice, maybe to organize another webinar about the case coming up. So what I simply wanted to say, and I would like to thank very much Robert for your article, because I think it's a true gift for the European Law Journal. And why it is so? It is because indeed it will be the lodestar of our special issue on the rule of law. Because the reason why this article is really special is that it shows that defining the rule of law is a rule of law exercise in itself. And second, it takes conceptualization seriously. Why do I say that? I think that precisely it operates a very nice merger between a philosophical approach of the rule of law, which would define the rule of law as tempering power, and a judicial approach to the rule of law, which means that tempering powers, when we temper powers, it is by law. So there's a nice convergence in your article and the basic of your article, which is very fundamental. But why is it also special is that indeed it provides both a framework for understanding the rule of law in the convention context and a guide on how it concretely operates in that system. And as we've seen by the comments of the speakers today, that's the reason why it will be very useful for scholars and practitioners alike. And it will definitely stand the test of time, because this conceptualization is flexible. It will, I do think we will see we never know, but it does allow to adapt to evolving circumstances and case. But indeed, what the article shows is that the rule of law is collaborative effort among courts and a multi-level exercise and dialogue between the European Court of Human Rights, the Court of Justice, and national courts. And actually, in this regard, I don't want to take too much time, and I will just have one question, which is actually a request, which is basically you speakers, judges of the Court of Justice and the European Court of Human Rights, could you please answer to each other's position? I think that would be what everybody is waiting, a dialogue also in this live, and comment on each other's position. And Robert, if you want to start, that would be absolutely wonderful. So now I leave the floor to Giuseppe Martinico, who has him more precise questions. Thank you very much.
Thank you very much. I don't know if he has more precise, but for sure we will have also interesting questions. Giuseppe is a dear friend of all of us. He's the co-director of Diritticomparati, professor of comparative public law at Sant'Anna in Pisa. And just let me mention his forthcoming, a long-awaited next book for Cambridge University Press, Filtering Populist Claims to Fight Populism, ? The Italian case in a comparative perspective. Giuseppe, the floor is yours.
Good afternoon, everyone, and thank you very much to Oreste. Thanks to President Spano and the other distinguished speakers for this debate. I really enjoyed the article and the comments made so far. But as I'm standing between you and the Q&A session, I try to make my intervention brief. I have a comment and then two questions for President Spano, and they are all about the very last part of your article. My starting point is the following. If the rule of law is the lodestar of the European Convention of Human Rights, and I do agree with you about that, perhaps we can also say that the convention participates, to a certain extent at least, in the function historically performed by constitutionalism, namely that of limiting and shaping political power. As the Canadian Supreme Court once argued, constitutionalism and the rule of law present similarities, but they are not identical, in the sense that constitutionalism brings the claims of the rule of law to a further level by linking these claims to the necessary compliance with the higher law. And in this respect, one could say that the European Convention of Human Rights gives an added value to domestic constitutionalism. For example, in some countries, the European Convention has been treated as a sort of shadow constitution, in Austria, for instance, and it has been used by domestic constitutional courts to enrich the national yardstick used to review domestic laws. In other countries, the Netherlands, where there is no proper judicial review of legislation, national courts have benefited from the constitutional openness, and they have used the international treaties, including the European Convention, to remedy this situation. Over recent years, the Strasbourg court has been under attack. And sometimes this phenomenon is also due to the recent waves of populism and sovereignism that have spread around Europe, as you mentioned in the very last lines of your article by referring to Petro's article. In some cases, even the international commitments stipulated by national states have been the subject of discussion and resistance. The Swiss Law First initiative is a good example of that, in a system in which the European Convention and the Strasbourg Court play a fundamental role in giving national judges the possibility of carrying out a sort of judicial review of federal legislation by compensating, in this sense, a gap present in the Swiss system. Against this background, and here I come to my first question, do you think that the alliance with national judges, especially top courts, an alliance in a way reinforced by Protocol 16, could help the European Court of Human Rights in explaining that the European Convention enriches the protection of constitutional rights, and in explaining that the Strasbourg Court is not a threat to national sovereignty. I'm asking this because with the Diritticomparati, we have tried to contribute to the Italian debate about the advantages offered by Protocol 16. Unfortunately, in Italy, the non-ratification thesis has also been supported, among other things, by sovereignist arguments. My second and last question is the following. In some countries, in order to face populist attacks, constitutional courts have been trying to better explain their mission to citizens, to reach out to people, so to say, by investing a lot in communication strategy. Members of the Constitutional Court do podcasts, they give interviews for newspapers, they participate in cultural, non-academic events. This has triggered the huge debate about the pros and cons of this choice. Are courts equipped to do that? Is that useful? My question for you is the following. Do you think that the Strasbourg Court should adopt a similar strategy to tackle the sovereignist narrative? Thank you very much.
Thank you very much, Giuseppe. Those are very interesting questions, and I think there will be time for answering. And now it's time for me to pass the floor to, I mean, I already used the word engine, but in this case, it's the organization and I would say promotion, even if you want ideal engine of the event. It's Daniel Sarmiento, his great team of EU Law Live that now will chair the final part of the webinar. Daniel, the floor is yours. Thank you very much.
Thank you very much, Oreste. It is my honor to join you all and to have this this possibility of addressing you as well. But my role here is very limited, and I will be trying to put some structure in a session which will have to be short. We're running out of time, but we have lots of questions and we have a magnificent array of speakers. So I think that in order to try to be efficient, I will give the floor to President Spano, because from our distinguished speakers and discussants, we already have many comments and many questions addressed to him. So I think that in the first round, we can give the floor to him. And afterwards, I already have some written questions, and I invite our attendees to send written questions as well, but we already have some written questions. So in the second round, I will send those questions to our speakers more generally. And in that round, you also will be able to interact between the speakers. So President Spano, you have the floor now.
Thank you very much. Let me immediately go to the questions posed by, or question posed by Karine, dealing with some reactions to Judge Kowalik and Advocate General Pitruzzella, the points they made. I think the most salient point mentioned by Judge Kowalik is, I think, when it comes to the axiological convergence, is, I think, a realization of the main challenge, which I think posed by the two systems, is the fact that the Luxembourg court, the European Court of Justice, the way it is presented with the questions, usually within the context of preliminary references or based on infringement proceedings, is of course a paradigm which is different from the way in which applications are lodged at Strasbourg by individuals in actually lived cases where they are pled after we have had a full domestic proceeding and a final outcome. And that, I think, goes to the core question presented by Judge Kowalik, which I think is correct. To what extent does there remain some questions as regards the consequences, the remedies to be afforded when we find in Strasbourg violations of Article 6? Now, here I have to be very careful. There are questions here which remain to be dealt with. What I do think transpires from Guðmundur Andri Ástráðsson, and I think the judgments which I have alluded to, is that because the independence of the judiciary operates as a legal principle and within both the organic and functional dimensions, we are not viewing this as just one component in an overarching framework of fairness. We are viewing this as a fundamental pre-existing premise for judicial proceedings that can be considered or can fulfill the requirement at the existential level of being fair. Now, how that plays out in different cases is, of course, something we will have to grapple with. As regards Advocate General Pitruzzella's intervention, I'm very happy to hear that an eminent constitutionalist is in agreement with the bottom line that the convention concept of the rule of law is one which is closer to the Binghamesque thick version of the concept rather than the Rawlsian thin-based version. That is, I think, as a matter of narrative and as a matter of doctrinal starting point, that's a very important point to make. And that brings me very finally to Giuseppe Martinico's questions, because they both deal with the element of transversal European constitutionalism. You're absolutely right, Professor Martinico. It is clear the convention, and this goes back to some of the articles I've written on the principle of subsidiarity, the overarching framework here, the reason we want, the fundamental driving force of the convention is an extremely close cooperation between the Strasbourg court and the national judiciaries. I have called this the European community of judges. The convention, and I say the same, the EU system, cannot function unless the first instance judge, whether it be the first instance judge in Lyon, in Warsaw, wherever, if he or she is not in a position to adequately implement and understand the benefits of implementing convention case law or charter case law, and that case law has a level playing field based on a conceptual clarity, then of course the whole system is under threat. So both my role, the role of Judge Kowalik, the role of Advocate General Pitruzzella, the role of Judge Sabato, is to have an interaction between us and the national courts, which is fruitful and open and towards a realization that absolutely yes, the convention as being an international law obligation and an obligation which needs to materialize domestically will, of course, in that respect, have an immediate impact on the way in which the constitutionalization of rights at domestic level develops as an organic framework where international law and domestic law are uniting as a force for good. Coming to your second question, again, why am I here? Why am I writing these articles? Why is Judge Sabato here? Why are our colleagues from the Luxembourg court here? That is because in the 21st century, courts, especially international courts, cannot hide behind the proverbial Rawlsian veil of ignorance. We have to be present. Now, of course, the way we are present is, of course, different in the extrajudicial sphere than it is in the judicial sphere stricto sensu. Judge Sabato made this point very eloquently. What we are saying here now in this fora is meant to be a part of a narrative, a debate, the possibility for us to come closer to those that are the beneficiaries of our judgments. So absolutely, yes. I think it is part and parcel of a holistic approach of public relations to try to make us as much as possible alive in the hearts and minds of peoples all across Europe.
Thank you very much. I have, before I give the floor back to President Spano and our speakers, so they can also react to their respective interventions, I have some questions that we have been receiving through our system of questions. The first question we have is from Miaela Mazilu Babel, and she is making a specific question about a feature that will probably be adjudicated on at the court. So I think that we cannot address this question very, very directly. She's questioning why open the debate about the possibility of reviewing European arrest warrant decisions at the Strasbourg level in light of Article 6, considering that this is something that has already been solved in the negative in the past. Since I said before, this is something that might ensue once again before the courts. I will not frame the question in so specific terms, but if I will be allowed to rephrase it a little bit, I think that there is a good point being made here regarding the fact that we are facing a reality that is constantly changing. And for example, in the case of the Luxembourg case law, in the Selmer case, in which the court, although it set a decision, it also opened the possibility for future developments in its case law, depending on the evolution of the facts. So maybe we could reformulate this question in the sense of considering the fact that the convention is a living instrument, as the court has stated many, many times, how does that living instrument evolve together with evolving circumstances when we are witnessing at the moment changing circumstances, societal circumstances that are changing very, very, very fast? And I think that the questions being raised by Giuseppe to the fact that we have a rising populism is part of that changing context in which we are in. We have another question by Lucia de Oliveira making a reference to how does the fact that we are facing populist perspectives from member states, is that affecting the conception of judicial independence? I think this has been already addressed in the question by Giuseppe Martinico, but if any of the other speakers want to react, because the question is coming back again, then I think that would be very good. So I will give the floor back to President Spano, and immediately I will give the floor to the speakers so that they also profit from the possibility of reacting among themselves in the same order that we have followed previously. President Spano, the floor is yours.
Thank you very much. I think we have to be careful when we refer to or use the concept of or the living instrument doctrine, at least from the perspective of Strasbourg case law, because then we are talking about the way in which the convention and convention rights evolve due to the emergence of a European consensus within a certain field. Usually the living instrument doctrine has been applied in cases dealing with delicate social, moral, and ethical issues. I would caution in using the living instrument doctrine as a requirement for us to integrate into the case law factual changes in the various member states, which have to be taken account of in simply applying convention provisions like judicial independence, where the text of the convention, where the concepts that we are talking about start from a level of clarity, which perhaps we haven't seen in other situations where the living instrument doctrine has been applied. In other words, the convention can never operate in a vacuum. It goes without saying that the way in which we understand the rule of law will, of course, develop as we see how member states and political developments treat that concept, and the way in which evolutions in the member states have an impact on our understanding of what these concepts mean. But I would not use the living instrument doctrine in that context. I would rather say, to answer your question, of course, both the Strasbourg court and the Luxembourg courts must be alive to the factual developments occurring at any given moment.
Thank you. Judge Kowalik.
Thank you very much. Maybe I will start with the final question from the speech of President Spano that has been mentioned in his answer, whether and to what extent the development of jurisprudence concerning European arrest warrant can be perceived as contrary to Article 6. I agree that there is a big paradox there, because the idea that started with the judgment LM, that was as well called today Selmer judgment, it has been anonymized, so I use the anonymized version, is that by asking the preliminary question on the possible systemic breach in a different member state, the court that has asked the question is given a very difficult task, because the court has to identify whether there is a systemic problem, and second, in the second term, it has to identify whether for an individual this systemic problem might result in not having an independent authority judging his or her case. And of course, the very big paradox of this second step is that you might have a perfectly independent judge on the board, but he is becoming a victim of the systemic breach, because he cannot defend himself saying, I am actually independent. It's the system that is probably sliding down. So that's the big paradox, and I would be very careful in identifying the infringement of Article 6 in these circumstances. But of course, it will come with different cases and different configurations. We only have to wait. And I probably has been avoiding a little bit the Polish issues in my speech by the very idea that I'm probably not very objective, but because in Luxembourg we are actually avoiding to adjudicate in the national cases. It's a very big difference with the Strasbourg system. So I allow myself this comment without getting into much broader details. Now, as to the questions of Giuseppe Martinico, in the time of when our constitutional tribunal has a little bit different character, one of its judges, Professor Łętowska, was always referring to the idea of constitutional pluralism and multiplicity of sources of the constitutional order in Polish system. And I think European Convention has been perceived as an element of a sort of external constitutional order without any problem. So it has been a source of inspiration, and it has been sometimes even a source of obligation. So it can function. The question of the alliance with national judges, from the perspective of the Luxembourg court, and in particular the mechanism of preliminary questions, the recent years has shown that at least from the Polish perspective, there is a strong alliance between the application of the Charter of Fundamental Rights preliminary question system and national judges, because you can even perceive it as a sort of a last resort board in some cases, where within the national system you cannot perhaps find a good remedy to prove your case, so you are going out to Luxembourg. But the problem with Luxembourg, if I can call it a problem, with the Luxembourg system is that the national judge is asking a question on the interpretation of European law and will have to deal with his or her national problem in a very intelligent way by applying this answer to the concrete national case. So this is not always very, very easy. As to the fight with populism by going out to the public, if I were to be precise, we the judges of the General Court and of the Court of Justice, we are bound by the so-called Code de Conduite, and we are actually bound to be rather reserved in commenting our reality. But I think if you resort to a little bit, either commenting the judgments that has been already rendered, or by keeping a certain level of generality, you can very well achieve the idea of spreading the information on how the European courts actually function. I think these have been the questions that I have identified. If there is anything left, I will be happy to answer.
Thank you very much. I now give the floor to Advocate General Pitruzzella. Advocate General Pitruzzella.
Giovanni.
Thank you. I had the problem. Can you, okay, listen to me?
We hear you, yes.
Can you hear me? So the debate has been really, really interesting. There are a lot of food for thoughts, and I limit myself in just 2 or 3 remarks. First of all, Sarmiento spoke about the evolution, the existence of changing circumstances, the necessity to adapt our jurisprudence to this. I think that there is a challenge in our future. How to introduce the rule of law in the field of internet. I think it's a challenge because I think that the rule of law concerns our real life, but in the world of internet, some fundamental principles, such as the right to effective judicial protection, are not in force, doesn't work. So it's a challenge for us. Then another remark. According to many scholars, constitutional pluralism is the paradigm used to frame the complex relationship between European Union, the system based on the Convention of Human Rights, and the constitutions of the European states. It involves the existing of 3 interacting legal orders. And the main problem is to find an overarching framework for management and resolution of conflicts between constitutional orders while still preserving their autonomy and not integrating them into a new whole. This framework serves a bridging function between the orders. There are some meta-constitutional norms, interface norms properties, which regulate to what extent norms and decisions in one suborder have effect in another. But there is another way to bridge the suborders by the elaboration and application of common legal concepts, expression of common values. The rule of law, in my opinion, is one of these concepts which frame the European pluralistic constitutional order. That's all.
Thank you, Advocate General. Judge Sabato, the floor is yours.
Thank you so much. I will say just very few words on the European arrest warrant issue, because probably that is needed. It is like our participant put it, for the moment, Professor Sarmiento opened the window for the future and what will happen in the future, at least in Strasbourg. We have, of course, a more limited perspective on the European arrest warrant, because in the decision that our participant mentioned, this Monedero Angora versus Spain, the court has just applied its traditional rule concerning expulsions of aliens and extradition, in which, you know, the execution of orders coming from the judiciary is not itself under the umbrella of Article 6. And so this has been also applied to the European arrest warrant. And the European arrest warrant has been only bypassed very closely, but without going on the merits, in two Grand Chamber judgments, Beuze versus Belgium a couple of years ago, and of course Avotins versus Latvia of 2016. What I would say is that should I follow, I'm in no position to make, of course, forecasts, but should I follow Professor Sarmiento's perspective, after Gudmundur Andri Astradsson, the picture may change, because there we have this concept of quality of the judge, which is a prerequisite for we don't know yet, because of course this is left to domestic systems. It is a prerequisite for what? But of course, if there is a violation in itself, and Robert Spano clarifies it in a very clever way in his article, saying that there is an irrebuttable presumption of a violation in case of a wrongful appointment of a judge, you cannot really foresee how far this sort of defect goes, because at the moment it stops at the judicial measure and does not propagate to the execution of it. And that's the traditional doctrine in Strasbourg. I could say that plus included minus, and therefore, you know, the future could be different, I would say. So that's my answer for the moment. I'm sorry, I cannot say more. Giuseppe Martinico and our participant, Ms. De Oliveira. The role of populism, what should courts do, the referral, the reference that Giuseppe made was to constitutional court, but of course I would answer for domestic judiciaries, and I already said the way that the European Court of Human Rights lives this experience of relationship with the outside world. I would say that populist discourse, being part of the expression of society's need, should be very, very carefully assessed by decision makers within the judiciary. I have brought before me the thing that I quoted before by heart, that recommendation of 2010, which I mentioned, and this paragraph 20 of recommendation number 12 of 2020 of the Committee of Ministers says judges who are part of the society they serve cannot effectively administer justice without public confidence. So populist talk, when it infringes confidence, makes it impossible for judges to work. They should inform themselves, the judges, of society's expectations of the judicial system and of complaints about its functioning. So a strong role on judges being aware. And then, of course, there are other suggestions, as I mentioned before, permanent mechanisms of taking feedback from society, and also having press offices and other communication officers in the court. I would also mention this opinion of the CCJE, which is called Justice and Society, which goes as far as opening the doors, which many courts do, to students and other society issues. I think that's the only hope for a judicial activism, which is not only done at one's desk and dealing with legal concepts. I would say this is very, very important. Let me end by saying that in one little, I think, again, a footnote or somewhere of President Spano's article, we have an important reference to one of the passages of Gudmundur Andri Astradsson, where it makes reference to separation of powers. Because, you know, all of this talk comes usually from politicians or from new form of political actors in society. And so they are usually, in many countries, members of parliament or of local government. This paragraph of this paragraph of the Grand Chamber judgment 215 says that, of course, Article 6 does not define the rules that govern separation of powers. Therefore, the powers should interact. And this also includes that respect of the de facto independence, which we commented before, unless they encroach. I think this is the verb used in English, unless they encroach. So I think that in order to avoid this encroachment, both interlocutors should pay caution. So not only those who practice populist talks, but judges, national judges, constitutional judges, international judges, and European judges among those should be very, very careful. That would be my approach. Thank you.
Thank you very much, Judge Sabato. We're almost 2 hours running, so this means that we are very considerably beyond our original schedule. Of course, we still have questions pending. We have questions from Catalin Corteza, Elise Payot, Serena Menzione, Manuela Sanchez Gomez. Unfortunately, we do not have time to make another round, but I would invite our speakers who will be submitting short contributions that will be published in Diritticomparati and at ELL Live to take into account some of the questions that are being submitted, because they are interesting, including, for example, what protection do lawyers need if we are discussing judicial independence? What about other professions which might see or find themselves in situations under certain public measures? We have questions on the possibility of legislating on rule of law issues at a European Union level. We have some very stimulating questions coming from our participants. So I do invite our speakers to reflect on them when they do work on those short contributions that will be published shortly. Just very briefly, I would like to thank once again our keynote speaker, our distinguished speakers, our discussants. We can't applaud as we would in a live setting, but we, I think we all share this feeling of thankfulness for the time, for the commitment, for the willingness to reach out, to open the debate. And now that we can do it in these digital circumstances, despite the difficulty and the unfortunate circumstances that they are indeed also an opportunity to reach a broad audience. So thank you once again.